Today, we dive into the world of justice and accountability as we take you on a roller coaster ride through the courtroom dramas where dirty cops face karma for their dirty actions. First up, in 2019, a former deputy named Joshua Underwood created a stir when he barricaded himself inside his apartment, necessitating the intervention of a SWAT team. Deputies initially tried to evict him, but upon entering his apartment, they found him armed and uncooperative. The situation became more complex due to Joshua's background as a deputy sheriff with the Oconee County Sheriff's Office, leading to the involvement of South Carolina Law Enforcement Division. Fortunately, negotiations led to Joshua's peaceful surrender. He faced charges of resisting arrest and was relocated to the Greenville County Detention Center. During the eviction, a .40 caliber handgun was discovered. Joshua was later transferred to the Oconee County Detention Center, and the live courtroom footage will reveal the events.
I'd like to hear from the Solicitor's Office and the Sheriff's Department before I make any decisions regarding bond for Mr. Underwood.
Yes, sir. May it please the court, Judge, just to clear up any issues regarding the warrant, the warrant is resisting arrest. However, I think what Mr. Underwood's maybe misunderstanding about that is that the resisting arrest also encompasses resisting the service of process or a writ. That is the specific portion that is being dealt with in this particular case. This situation arose when representatives from the Sheriff's Office went out to the residence where Mr. Underwood was staying and attempted to serve him with paperwork for an eviction. Mr. Underwood refused to accept that paperwork, so at that point, officers came back, obtained that warrant, and went back to serve that warrant. So that's how we got to where we are with regard to the warrant. Living with him at that residence, and I believe the primary person at that residence is the mother of Mr. Underwood's child. I don't believe they're married, but they do have a child in common. Certain statements were made while the situation was going on yesterday with regard to the standoff. A gun was obtained by law enforcement at the time of the arrest. Mr. Underwood did say that was his weapon and intimated to officers that it was not for use on officers, but it was for use on his child's mother. Given those circumstances, there was also some marijuana in the residence that was turned over to narcotics as well at the time of the arrest. I don't know that any charges have been made with regard to those drugs. That's something that we'll be dealing with at a later date. But for today's purpose, what the state would be asking for is a cash or surety bond. We would request a bond of approximately $50,000. And we also believe that based upon the statements that Mr. Underwood has made, intimating potential harm towards his child's mother, we believe that GPS monitoring, ankle monitor is appropriate in this case. We would also ask that the bond specifically include provisions prohibiting him from going to her place of work and to her residence. And certainly we can furnish the addresses to the monitoring company so they can go ahead and plug that into the monitor so they'll be notified if Mr. Underwood goes to either of those places. I think that's all we're asking for today. Any other issues certainly can be taken up at a preliminary hearing or at the appropriate time later on.
Okay, thank you.
Thank you.
The judge then goes ahead to reveal Mr. Underwood's bond amount and outlines the serious repercussions of his actions, yet this former deputy refuses to stay quiet.
All right, Mr. Underwood, I find the solicitor's request for a cash or surety bond of $50,000 to be reasonable accordingly. I'm going to impose that cash or bond for your release.
I find it absurd that you haven't even obtained any information from me based off the solicitor. You're going to believe everything he says.
Okay.
And you're going to go ahead and set a surety bond on me on a misdemeanor.
Okay. Are you finished? Okay. If you'll hear me out, please. Thank you. Additionally, I'm going to place a requirement for a GPS monitor prior to your release on bond. I'm going to restrain or restrict your contact with your domestic partner or the mother of your child, whichever best describes her, to include her place of work and her residence. Additionally, I'm going to prohibit your physical or constructive possession of firearms or ammunition at any time for any reason. And I want to make sure that you understand, when I say constructive possession, I mean there's to be no firearms or ammunition in any vehicle you're being transported in or riding in unless it's...
What ground? Are you prohibiting me from firearms?
I am.
Why? What ground?
I am, because I have that latitude, given the severity of,
What reason is you're
Sir.
why are you standing behind it, that you're gonna
Mr. Underwood,
firearm?
Mr. Underwood, in this court, one person talks at a time.
From the solicitor's office and the sheriff's office.
You're gonna find yourself in contempt of court,
I've already been in contempt.
Okay.
I'm not here, sir.
all right? Are you gonna allow me to finish? Constructive possession of firearms or ammunition means you will not have it in your possession, it won't be in the house or the room that you're staying in, it won't be in the vehicle that you're being transported in, unless we're talking about transport by law enforcement. Do you understand that? All right, that's all, you're dismissed. Officer, if you'll remove him.
You can't look at me, can you? You can't look at me, can you? Which one?
Do you have any questions?
No, sir.
Okay, sir.
Joshua Underwood was clearly frustrated, found himself facing his karma in the courtroom, and the judge eventually had no choice but to dismiss him, directing the officer to escort him out. Next, we move to Denver, Colorado, where Anthony Waller is facing a series of allegations, including false imprisonment and assault on a female victim at a local motel. Judge Doris Bird outlines that he will be held in custody during the investigation. Waller is representing himself with police officers surrounding him. One of these officers, Deputy Brady Lovinger, who is known for his anger management issues, and this is about to become apparent.
Investigation for false imprisonment, assault in the third degree, assault as a class 2 felony, and a misdemeanor charge as well in possession of drug paraphernalia. Thank you, sir.
Yes, ma'am. I'd like to object first. If I'm under investigation, I thought the investigation came first, and then the arrest came.
Right, but they have 3 days.
Get up. Get on your feet. You don't turn on me. Boy, this is the ERU SWAT team. Get on your feet. Get on your feet. Where's the taser? I can't move, man. Get on your feet. Oh, man. Get on your feet. My hands Don't turn on me.
The sheriff will have to serve.
Don't give a shit anymore. You're not poking me. You're not turning on me.
Following Deputy Lovinger's use of excessive force, where he slammed Waller into a glass window, the judge swiftly filed an excessive force complaint against Lovinger. Subsequently, an internal investigation was carried out, which resulted in Lovinger being suspended for 30 days. Moving on, let's shift our focus to Brooklyn Center, Minnesota, where we find former police officer Kimberly Potter awaiting her sentence. Potter's conviction stems from the tragic incident in which she mistook her handgun for a taser during a traffic stop in 2022, resulting in the fatal shooting of 20-year-old Dante Wright. She had been found guilty of both first and second degree manslaughter charges.
To the family of Dante Wright, I am so sorry that I brought the death of your son, father, brother, uncle, grandson, nephew, and the rest of your family to your home. Katie, I understand a mother's love, and I am sorry I broke your heart. My heart is broken for all of you. Earlier, when you said that I didn't look at you during the trial, I don't believe I had a right to. I didn't even have a right to be in the same room with you. I am so sorry that I hurt you so badly. My heart is broken and devastated for all of you. I pray for Dante and all of you many, many times a day. He is not more than one thought away from my heart, and I have no right for that, for him to be in my heart. I do pray that one day you can find forgiveness, only because hatred is so destructive to all of us. And that I pray peace will always be with you and your family. Again, I am so sorry. And to the community of Brooklyn Center, I do owe you an apology too. I loved working for you. And I am sorry what has happened to our community since the death of Dante. And the men and women who work for you still are good, honorable people and will work hard for you. Thank you, Your Honor.
Thank you, Ms. Potter. Okay, this is one of the saddest cases I've had on my 20 years on the bench.
Judge Chu then explained the reasons that she thought justified a more lenient sentence for the deputy. These reasons included Potter's intention to draw her taser instead of her handgun, the chaotic and tense nature of the scene with Dante, which required quick decision-making by Potter, and the fact that her actions were not motivated by personal animosity towards Wright.
Contrary to the state's claims, Kimberly Potter did not abuse her position of authority. In fact, it is undisputed Ms. Potter or Officer Potter was in the line of duty and doing her job in attempting to lawfully arrest Dante Wright on the warrant when she mistook her gun for her taser. What's more, she drew her taser legitimately to protect a fellow officer on the other side of the vehicle who could have been dragged and seriously injured if the car were to speed away. Officer Potter's conduct clearly was not significantly more serious than that typically involved in the commission of the crime in question, justifying an upward departure.
Judge Chu then proceeds to announce Ms. Potter's sentencing in the aftermath of this tragic incident.
Ms. Potter, will you please rise? Given all these considerations and having carefully considered the comments of the family of both Dante Wright and the comments of Kimberly Potter, as well as the arguments of counsel, it is the sentence and judgment of this court that you shall be committed to the custody of the Commissioner of Corrections for a period of 24 months. You shall serve 2/3 of that time, or 16 months in prison, and 1/3 on supervised release, assuming no disciplinary offenses or conditional release violations. You have credit for 58 days already served. Restitution will be reserved. There'll be a fine of $1,000 and a surcharge of $78 to be taken out of prison wages or due within 180 days. You must provide a DNA sample. You may not use or possess any firearms, ammunition, or explosives. You have the right to appeal the conviction and sentence. If you are unable to pay the cost of an appeal, you may apply for leave to appeal at state expense by contacting the state public defender. You may be seated, Ms. Potter.
In the end, this deputy couldn't run away from her own karma as she was sentenced to 24 months in prison. Up next, in Breckenridge County, Kentucky, we find former 51-year-old Sheriff Todd Pay standing before Judge Jeanette Cooker. Back in 2022, Deputy Pay, while driving his personal vehicle, was involved in a serious crash that resulted in injuries to 4 individuals. However, he fled the scene of the accident, and when he was eventually arrested later that night, his blood alcohol level was found to be twice the legal limit. Subsequently, he was released on bond and chose chose to retire from the sheriff's office. Today, he's in court to change his plea from not guilty to guilty, a decision he has already conveyed in writing. This plea change could potentially reduce his sentence to just 75 days in jail, compared to a possible 15 years if he had gone to trial and been found guilty of all charges. All he needs to do is verbally confirm this decision to Judge Jeanette Crooker.
At this time, is it your desire to change your plea from not guilty to guilty?
Do I have to answer that yes or no, or can I make somewhat of a statement?
That is a yes or no answer, sir.
Will I have the opportunity to say anything further?
If it is your intention to change your plea from not guilty to guilty, certainly you'll have an opportunity to make any statement. But if it is not your intent to enter a guilty plea at this time, then I'm going to set your case for jury trial, and you're going to stop wasting my time and everybody else's time this afternoon.
Ma'am, I'm not trying to waste your time.
And then is it your intention to enter a guilty plea at this time or not, sir?
No. Why am I wasting your
Mr.
time,
Chambers?
ma'am?
They then go for a small recess and regather at the court again.
Let's get back on the record and see if we can sort this out. At this point in time, what is Mr. Pate's decision with respect to his guilty pleas?
So I believe I'll just let him answer that question if it pleases the court.
All right. So, Mr. Pate?
Can I say a few things, or?
I need to understand what it is that we're
I would
doing
just
here
like for
today,
the
Mr.
court-
Pate.
Yes, I had every intention of coming in here today and entering a guilty plea. It's difficult for me to enter a guilty plea for a lot of reasons, and I don't want this court to think that I am trying to minimize any responsibility that I had in this situation that occurred. I feel like I'm being very much bullied into doing something that's not right, and I want this court to know that Todd Pay holds himself responsible for everything that he did. It's hard for me to lay down and plead to felony charges that don't apply.
Is it your intention today to enter this guilty plea?
And if I could address...
This is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny. Let me just plea and get it over with for everybody. Plead to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. If you can sleep with it, I can sleep with it.
The judge then gets fed up with Pay.
I think we're done. At this point in time, I think we're done. Where I think we are today is that on the one hand, the Commonwealth can enforce the terms of this agreement based on the execution. Mr. Pate, I'm talking at this point in time.
Okay, I'm sorry.
At this point in time, I'm going to sustain the Commonwealth's motion to revoke his bond. He will be taken into the custody and housed in the Breckinridge County Jail.
Your Honor, if I may speak to Mr. Chambers' motion to revoke the bond.
I've already ruled. I've already ruled at this point in time.
Ma'am.
We're done at this point in time. He's going into jail today.
Pate eventually pleaded guilty and accepted the terms of his sentence, which was 75 days in a county jail with credit for time served.